Hi, I'm Mark Tobey, Special Counsel with the U.S. Justice Department Antitrust Division. I'm here today with Kevin O'Connor. Kevin, I've known you for a long time. I was with the Texas Attorney General's office for 20 years, and I've worked with you as a state colleague for probably 15 of those years, and I've seen a lot of you since then, but I'm really pleased to have the opportunity to interview you for posterity. Can we start out with a little bit about where you grew up and what you did before you were a lawyer?
Sure, Mark, and thanks for being here today, and I look forward to this conversation today. I was born in Madison, Wisconsin, grew up in the Fox Valley, northeastern Wisconsin, just 20 miles from Lambeau Field. I'm probably the section of antitrust law's most ardent Green Bay Packer fan. Beyond that, I'm not sure there's much more about my background that would be of that much interest to the antitrust bar posterity. So I think I'll leave it at that.
So how did you get involved in antitrust law, and what interested you about it?
Well, when I went to college at the University of Wisconsin, I studied economics, majored in economics and political science, and I always had an interest in public policy and problem solving, trying to understand how the world worked. And I went to college at a time when there was a lot of ferment on the campuses, and people were asking a lot of questions about public policy. And so I decided then to go into law and economics as a joint major, and ended up going to Harvard Law School and took a number of antitrust courses there for professors like Arita and Turner, and actually did some graduate economics work over at Harvard College, studying with Richard Caves and Michael Porter in an I.O. class, and then later became Professor Caves' teaching assistant in an I.O. class at the college. I then came back to Wisconsin and finished up my PhD in economics, and I think my interests continued to evolve because, as you know, in the late 1970s, there was a lot of ferment in the antitrust economic area about the Chicago School and the application of basic economic theory to antitrust law, and that piqued my interest to a great degree.
Well, someone with a PhD in economics and a law degree from Harvard could have gone anywhere and done anything in the law. Why did you go to the Wisconsin Attorney General's office?
Well, that's a little bit of a story there. After graduating from law school, I needed to go back to Madison to finish up my prelim work and my coursework for the PhD, and so I took a clerkship with Judge James Doyle Sr., who's the father of the current governor, who was later one of James Doyle Jr. was an AG that I worked under for 12 years. But I came back to Madison in the 70s, mid to late 70s, to clerk for him while I was finishing up my coursework at the UW in economics. I then took a job at a big law firm for a number of years and did not make much progress on my thesis. So when a job opened up back in Madison at the Wisconsin Attorney General's office in antitrust law enforcement, I seized upon that as an opportunity to both get some practical experience and finish up my doctorate in the city where my professors were all located. So that's how I ended up there. Now, why did I stay there? I mean, the plan was to go there for a couple of years and then move on, but the job became more interesting in the 1980s. And frankly, the idea of going to the federal agencies in the early 1980s was not as appealing as it might have otherwise been because of the change in administration at that time. And my concern was that the enforcement of the antitrust laws would not be that vigorous at that time.
So what was going on in Washington that caused you to not want to go there?
Well, there was an election in 1980 that most people remember of a certain age. And with the Reagan election in 1980, things changed over in Washington quite dramatically, as is well known in antitrust circles. And the Chicago School of Economics became much more prominent. I came out of a tradition at Madison where it was more empirically based, and people, the professors and the researchers, were looking at markets from the perspective of what are the facts on the ground about these markets, as opposed to just applying pure theory to the markets. to the analysis. And so I was concerned that that would not be the best place for me. Now, on the other hand, I was thinking I would go there eventually when I got some more practical experience and did finally get my PhD dissertation done. But
so what was the state antitrust enforcement practice like at that time?
Good question. The Wisconsin Attorney General's office in the early 80s had a very active antitrust program. In the 70s, they had prosecuted a large number of bid rigging and price fixing cases. In fact, virtually every major building and trades contractor in the state had been prosecuted at one point or another for bid rigging or price fixing. So it was a very active office, and I got some very practical experience early on prosecuting some bid rigging and price fixing cases and working that angle with experienced criminal prosecutors. They had most of them had sort of gravitated away from the straight antitrust cases to blue-collar criminal cases like murders and that sort of thing. But I was sort of slotted to do more of the antitrust prosecution. But at the time, by the 1983, 84, 85, it became apparent that the states were going to become more active in antitrust enforcement. I wasn't a leader in the group at that time, but I became very aware of it, and because of my law and economics background, I immediately seized upon the activities of the Eastern State Antitrust Committee. You must remember some of this. There was a group of states out on the East Coast, led by New York and Connecticut, New Jersey, Pennsylvania, that had a very active multi-state group, even if it was somewhat informal, underway. And eventually that morphed into what we call today the Multistate Antitrust Task Force, which is a national group.
So who were some of the people that were instrumental in antitrust on the East Coast involving the ESAC?
The ESAC group. Well, of course, Lloyd Constantine was a prime mover in that group. Bob Langer, Laurel Price, Mike Brockmeyer. I know I'm forgetting some folks here. My apologies if I'm not leaving some names out. They were all very active in that group, and I learned a lot from them when we started to go to their meetings, and when I started to go to their meetings. And gradually the group morphed into a larger multi-state group. And they, for example, they started looking at minimum resale price maintenance cases very closely because the federal agencies, the Antitrust Division and the FTC, had essentially announced that they weren't going to enforce the antitrust law in that respect. And the states sort of picked up the baton and started bringing those kinds of cases. The states also came up with their own set of merger guidelines that contrasted in significant ways with the federal merger guidelines. I was not a leader again in that part of the process. But I was a very observant participant. Later in the early 90s, I was the leader in terms of revising the state's horizontal merger guidelines and vertical restraint guidelines at roughly the same time that the federal agencies were revising their horizontal merger guidelines and deciding not to pursue vertical restraint guidelines going forward.
So we're going to talk a little bit more, I think, in a few minutes about merger enforcement in the states. But before we get there, you mentioned the resale price maintenance cases. And most of those, as I recall, were settlements by the states. Did the states ever litigate cases together?
Well, you're correct. The minimum RPM cases were generally settled and not litigated to trial. To a trial. That said, they did involve some fairly significant investigations. Normally, those cases started with a discounting retailer complaining to a state AG that they weren't being allowed to cut prices on product. In some cases, they'd have huge inventories of product that they couldn't sell. And the cases really started with the Japanese consumer electronics manufacturers who were importing the practices they used in Japan into the United States without regard to the U.S. antitrust law. And so those were relatively easy cases to investigate and bring. Later, the shoe industry was the focus of a number of cases, and so on and so forth. But none of those cases, again, were litigated to trial. They were investigated and then settled with money going back to consumers. The first case that was really litigated by the states was the insurance antitrust litigation, or as it's also known, State of California versus Hartford Fire and Casualty Company. And that was a case that where the states became concerned because their municipalities and counties and other governmental entities found that they weren't able to get the kinds of insurance coverage that they thought they needed in the mid-'80s. And in fact, there were areas of California and some of the other states where police stations and swimming pools had to be shut down because they didn't have liability insurance. And the states did a preliminary investigation, but then decided that this was a case that was more appropriately handled by the U.S. Department of Justice Antitrust Division. And the states actually asked the division to handle that case and were promptly told no, they weren't. The division wasn't interested in investigating that case. As you know, Mark, boycotts, the insurance industry has, under the McCarran-Ferguson exemption, under the McCarran-Ferguson law, has an exemption from most antitrust laws, with the exception of boycotts. And we thought that this was it appeared to be an obvious boycott by the industry of certain kinds of coverages. And once DOJ said no to the case, the states began their own investigation that went on for a number of years, 3-4 years. The states principally involved in the early investigation were, I believe, New York, California, Massachusetts, and Minnesota, I believe. And they did quite a job taking depositions over in London of Lloyd's of London syndicates, and it was quite an involved investigation. And eventually the states filed suit.
Well, let me qualify that, because Texas was involved as well, and we were part of the multi-state group.
Well, there's a reason I forgot to mention Texas.
Right, until basically the day of filing. And I think that case might have been the first time I met you, and it because I came after the filing. I went to the Texas AG's office after the filing of the Insurance Services Office. The ISO case is what we call it. But I was certainly there in the courtroom in San Francisco when Judge William Schwarzer ruled in favor of the multitude of defendants dismissing the multi-state case.
You had to remind me of that. But let me go back and say, yes, that was an omission. Texas was definitely an instrumental, a very important part of the pre-complaint investigation. And Texas's decision to file in state court, however, made it a little more difficult to coordinate going forward, which is something that we learned about multi-state cases in general, that it's more difficult to coordinate when they're all filed in case they're filed separately in state court. That said, Texas, even going forward, was an important part of the case, and in particular, Aline Evans from the Texas AG's office was an important factor both in the litigation and ultimately in the settlement after the case had gone to the Supreme Court. But yes, and you had to remind me of Judge Schwarzer's dismissal of our complaint in the Northern District of California. That was not a pleasant moment for the states. But one thing I learned about that is when you go up to on appeal, you can essentially recast your case in some ways. We had pled the case as sort of a forms conspiracy that a number of large American P&C companies, along with many reinsurance companies, had, through the Insurance Services Office, as you called it, ISO, conspired to eliminate coverages from the standard commercial general liability forms, CGL forms, that municipalities use to get coverage, as a vehicle to get coverage. And when we pled it as sort of a conspiracy about the forms as opposed to really pleading it as a boycott in an economic sense, and that was unfortunate. But when we went to the Ninth Circuit, we realized the error of our ways, and we did a very good job, I think, of re-explaining the case, so to speak, and we won 2-1 in the Ninth Circuit. Eventually, the case went to the Supreme Court, and we won there on several issues, but the two most important ones were that the boycott exception to the McCarran-Ferguson immunity was sufficient to state a claim against these companies, that their conduct did fall within the boycott exception to the McCarran immunity. But secondly, and perhaps in a way, kind of a serendipitous way, the most significant holding of the case was the fact that several of the foreign defendants in the case, some of whom, like the Lloyd syndicates that I mentioned earlier, that had never set foot in the United States, but yet whose activities allegedly affected commerce in the United States, could be held liable in an American court under American antitrust law. This became later a very important precedent for both the states and for the federal agencies when they started bringing more foreign cartel cases. The fact that many of the defendants in those cases are in other countries or continents was not by itself enough for them to avoid liability under American antitrust law. And we feel quite good about that, and maybe we can talk a little later about concurrent enforcement, the pluses and minuses of that. But one of the pluses is obviously that if you have a number of enforcers, even where one decides not to bring a good case, if another one does, you create not only you're not only doing the right thing in that particular case, but that you may create precedent that is useful down the road.
What was it like litigating together as a group of states?
Well, that was interesting because, as you correctly point out, this was the first case that I think we ended up with 19 states, and perhaps the District of Columbia was a defendant. Was a plaintiff in the case. We had never litigated a case like that, and as you can imagine, being in different offices, having different bosses, trying to coordinate was very difficult. And that was right at the beginning of the PC era, personal computer era, and we all went out and bought personal computers, figured out a system where we could share drafts of pleadings and so forth, and we worked out a committee structure within our group to actually litigate the case. I think it was Tom Green, who was the antitrust chief in California, who said this was the first case in which a virtual law office had been created, and I think that was, as Tom Green is one of the more articulate people in our group, and that was a very apt description of what we had going here.
Well, there were some other highlight cases, I think, from the mid 80s and early 90s. What do you recall about those?
Oh, sure. I think the experience in the insurance litigation. Let me just finish up about that. The insurance case eventually went to the Supreme Court. We got the favorable ruling. On remand, it was settled, and relatively quickly. It was one of the more interesting mediation efforts I had, where a federal judge in San Francisco had another federal judge mediate the case, and he basically got us all on the same page. And at the end of the day, what happened is most of our clients, so to speak, the municipalities and counties that had lost the insurance coverage, essentially by that time had opted out of the commercial insurance market and had formed their own risk pools. So it was interesting fashioning a remedy in that case, which was mainly focused on ISO. We simply restructured ISO to be less of an entity dominated by large insurers, to be one that was more of had a broader range of the insurance industry on its board and public representation on its board, and as well as some money. But other cases, I think that our success in that case, in the insurance case, emboldened the states to do more litigation as a group. And in particular, there was the entree litigation, where led by New York, and Lloyd Constantine in particular, and Joe Opper in New York, as I recall, sued what they called Entree, which was the joint venture between MasterCard and Visa to jointly offer a national point-of-sale debit card. And we thought that each of them had the capacity to enter that national POS market in and of themselves, by themselves. And so we challenged the joint venture. They agreed not to do the joint venture, essentially. And later, they both entered with their own point-of-sale debit cards, the Cirrus and the Plus card. And we thought that that was another big success for the states on the injunctive relief front. And we had the Prime Star case involving the cable industry and the program sources. There was a number of cases like that came in quick succession. And I found it a very exciting time to be working on those sorts of cases. We also started getting more involved in indirect purchaser cases because these are cases where it's often very difficult for private plaintiffs to get classes certified. And the fact that the AGs can bring cases, many of them can bring cases on behalf of, as parents patria on behalf of their citizens, made it a little easier in some contexts for them to get that done. It's still an area that I think we need to work harder to get the private plaintiffs and the state AGs on the same page.
Well, you've been talking about conduct cases that required complex injunctive relief. What was the state's experience doing merger cases?
I think states had been doing merger cases going back quite a while. I recall being involved in some even in the early 80s, local cases, but it really took off when I think California was a state that was very much in the forefront in that area. And of course, we all know about the American Stores case, where they, after the FTC had signed off on a merger of two grocery store chains that involved 4 or 5 states in the far west, California decided they didn't think the relief was adequate, and they decided to sue. And that case went to the U.S. Supreme Court, and the Supreme Court held that the states had the authority to bring such cases under the federal Clayton Act, and more importantly, get divestiture as a remedy in those cases in the same way that a private party would be able to get divestiture if they had standing to bring the case. That was an important precedent and result, and to give the California folks a lot of credit for creating that precedent. But the states became very interested in mergers because many of these mergers had, even though they may have been national companies, they affected local markets to a great extent. Whether it was a grocery store chain, a bank merger, hospital mergers, I mean, you go down the list, almost all of them involve fairly local geographic markets. And the states had a lot of concerns about those cases. And I personally got involved in them fairly early on. And mainly because I was interested in them, as well as seeing an effect on Wisconsin citizens from some of these mergers. But from an economics point of view, it was fascinating to learn the way the federal agencies were applying economic theory and learning to the merger area. And many times I disagreed with how it was being done, but nonetheless it was a fascinating area on that level as well, not just on the practical enforcement level.
Was there cooperation between the feds and the states on mergers at that point?
You have to. There were times when there wasn't very good cooperation. I mean, it was very hard for the states to gain any credibility with the federal agencies early on. There was a feeling that there was very different approaches and different enforcement philosophies involving mergers in, say, in the mid to late 80s. It gradually started to improve with when Jim Rill took over the Antitrust Division and Janet Steiger became chair of the Federal Trade Commission. It became a little easier to work with folks at the federal level. When I started becoming one of the more senior leaders, for lack of a better term, in the group, I started encouraging the states to work more closely with the federal agencies because it was in our interest to do that. And yet it was still difficult. I mean, I remember when the merger guidelines were revised at the federal level in the early 90s, the states wanted, our goal was to try to converge as completely as possible with the feds. But yet it was difficult because we never really saw a draft of the proposed revisions until just before they were promulgated. And at that point, we urged a number of changes, a few of which were accepted, but not all of them. And consequently, we then did our own set of guidelines, and I think it was 93 they were issued. And we basically converged on most things.
What were the differences?
The main differences that remained, I mean, for example, the states adopted the federal agency's entry analysis completely. And in a number of areas, the analysis was, the guidelines were adopted completely by the states. One concern we had was on the product market definition side. The feds use the so-called SNP test, small but substantial non-transitory increase in price tests, to define product markets. Well, that's well and good, but what we had heard in talking to the agencies was that it's a fairly rare event when you have a really good data set and a robust data set that allows you to apply that test in full. And doesn't, not to say it can't happen. And my concern is that the guidelines at the federal level, this is just a general concern, was that guidelines don't exist in a vacuum. There is actually case law and a litigation context that surrounds the guidelines. And that if you say this is the preferred product market definition test, and then you as the plaintiff or prospective plaintiff are unable to meet that test because you just simply don't have the data, you're kind of put behind the 8 ball when you may go to court. I think the federal agencies, to be fair, did not view it that way. They did not view it quite as much as a litigation document. We had, I think because many of us had done a lot of smaller cases and been in court and done some of that stuff, we felt that the guidelines needed more presumptions. It needed more of a feel that this is trying to give transparency, but we're not going to be locked in, and we're not going we don't want the courts using these guidelines against the plaintiff in these cases if we have to figure out an alternative way to, for example, define a product market. So the state guidelines basically accepted the SNP analysis, but said as an alternative, we'll also look at other kinds of approaches to market definition, like the Elzinga-Hogarty test, and some other kinds of tests. If the data is not available for one kind of test, then we'll look at what is available. I mean, after all, the case law says look for the practical indicia of what the alternatives are to consumers out there. It doesn't prescribe, the case law does not prescribe a particular test. And so we felt that the guidelines should reflect that, at least at some level. And I mentioned the presumption issue. We had, if you look at the NAAG guidelines for horizontal mergers, there's several presumptions contained in those guidelines. In the federal guidelines, there's only, I think, 2, maybe 3 places. And those places where presumptions are present are there because the states urged the federal agencies to put them there. And I think that reasonable minds can differ on this, but I think that was an improvement in their guidelines.
What about efficiencies?
Oh, efficiencies, yes. The states always took the position that efficiencies ought not count unless they were passed on to consumers at some level. And I understand the economic argument that ought not matter in a pure sense. But from the perspective of people who are charged with the job of enforcing the laws and protecting consumers, we felt that that should be a part of the efficiency test. Now, the federal agencies initially did not have that in their guidelines. Later in the 90s, they did modify that section of the FTC DOJ guidelines to include a more robust statement of how efficiencies needed to be shown to have actually helped consumers. So we felt that there had been convergence coming from that direction as well.
There's another area related to the guideline projects that the states undertook in the vertical restraint area. Were you involved in that?
Oh, yes, very much so. And this was a much more difficult call on the part of the states because I think it was Ann Bingaman who had withdrawn the federal vertical restraint guidelines, and we seriously considered doing the same thing. The problem with vertical guidelines, as anybody who's in the business can tell you, is that you have many more permutations of possible markets affected in any kind of vertical restraint, and it can be very dicey to try to anticipate all of that in a set of guidelines. On the other hand, the states had been so active in minimum RPM cases and other kinds of vertical cases that we felt that, at some level, we owed it to the world, if not the business community, to explain what our thinking was, even if many out there may have thought it was erroneous. I also felt that it was important, in light of the importance of economics had assumed in antitrust analysis, to at least at some level outline what the economic empirical literature said about vertical restraints, at least what had been published. And frankly, when we went and looked for it, we found that there wasn't a whole lot out there that in terms of pure, solid empirical work. And yet we cited some of that in our guidelines, which was somewhat controversial in some circles, but we thought it was important to do that, just simply to explain what we were doing. Now, the vertical restraint guidelines of the states still exist, and they have become somewhat out of date in certain important respects. I mean, they currently don't take account of the Legion case or some of these other cases, so I think the states would do well to give some thought to what they want to do with that. I'm not providing any advice here. I'm just thinking out loud that it's a project that's worth undertaking because that is an area that's near and dear to state enforcers' hearts.
Well, I want to talk now about your tenure as the chair of the Multistate Task Force. How did that happen?
Well, I guess if you keep speaking up enough, people start thinking that you should move up the chain here. I was pretty much in awe of some of the people who had preceded me as chair, and I guess I was the fifth in the line of Lloyd Constantine, Mike Brockmeyer, Bob Langer, Laurel Price, and Tom Green immediately succeeded me. In fact, Tom Green and I were sort of up for it at the same time. That he had a boss in California who people didn't feel totally comfortable with, but I think probably not a good reason not to make him chair of the task force. Actually, the boss that we were talking about here is Attorney General Dan Lundgren, who eventually signed off on the Microsoft complaint. So, I mean, I think the fears were unjustified. But in any event, I became chair I think it was 95, and was chair for 3.5 years. And it was a real honored to do that. I really felt somewhat humbled by the expertise that was around the table whenever we had our multi-state meetings, and but it was I enjoyed the experience a great deal.
Well, what do you consider to be the highlights of your term?
Well, the highlights of my term. First of all, it was the thing people need to understand about the Multistate Antitrust Task Force is it's collaborative, and nobody really gets a whole lot done on their own. The whole point of having the task force is so that you can find other states that have similar enforcement interests and then proceed to work together and try to amplify the resources that you have. And my approach, I was the first chair who wasn't part of that original Eastern States group. And I came from a relatively small state, actually, perhaps almost a completely average state in terms of population and staff size. We had very little staff in Wisconsin, and I always felt that the task force gave me the opportunity to do good things for Wisconsin citizens, but also to make my job more interesting at some level, because I could participate in a couple, 2, 3 big cases at any given time without having to scrounge up several attorneys in my own office to work on it if it was a Wisconsin-only case. And so the task force, so you asked my highlight, what are the highlights? I'll get back to the question. I digress. The highlights were, number one, I think, just working with my colleagues from around the states and trying to herd the cats into a common direction. And the thing that you need to understand is that the task force doesn't actually bring the cases. It's the subgroups of states within the task force who decide that they want to work together and bring an action or investigate a matter or actually file a lawsuit. And managing that process was, I think, a strong point of my tenure as chair. I thought I did a reasonably good job at it.
Well, I remember something being
you take issue with that?
See there, I remember you as being a very, very strong advocate and had very strong views about case selection by the states.
Yes, I think I tried to. Obviously, one of the problems with being chair of that organization is you can't tell anybody what to do. I mean, everybody's there as a sovereign state, and they have the choice to make. But I did have strong views about case selection because I came from a small state. I came out of a criminal litigation background with my early days at the Wisconsin AG's office, and I always felt that one should, if you're in that kind of an office, if you don't have unlimited resources, you ought to focus on the local cases first. The criminal, bid rigging, price fixing, market allocation cases that nobody else is going to do unless you do them. And they mattered because they have, in addition to simply getting recovery in that case, they set an example both for the public and the business community and for the state agencies that needed to learn where to go with a complaint about price fixing or bid rigging. If you brought a case, it's amazing how fast people come out of the woodwork to tell you about other cases. And it took a while for me to work with people in our Division of Criminal Investigation, essentially the state FBI, who was our investigative arm. Those folks that were somewhat skeptical of some of the cases that we would investigate, but then when they saw that we would actually take them forward and charge people and get convictions and so forth, they got enthused about it. And so that was something I felt very strongly about. So number one, I always felt that was the number one priority for a state AG. Number two, I thought that civil cases where there was no prospective alternative plaintiff, either private or governmental, there was a widespread injury to consumers in the state, and or there was the likelihood of a need for complex injunctive relief. I felt those were the kinds of cases I should focus on after the criminal cases of a civil nature. When you work through all that, for example, price discrimination cases fall out fairly quickly. They're not going to focus on those. If the Department of Justice has brought a very effective action in some area, well, there's your alternative plaintiff, and presumably they know what they're doing, and presumably the state's the first impulse, or the default would be the state doesn't need to go forward with that case. And I felt very strongly about that, both in the civil litigation as well as in the merger context. Now, that said, I still think there's an important place for the states to have the authority to bring any case, because I think you need that possibility of the states filling a vacuum like we did in the insurance litigation.
Well, You and I maybe had a different view from time to time about what were the size of some of the cases we should be working on. And I certainly occupied myself for a time working on a big case involving Microsoft. And you were chair of the task force at that time. What do you recall about Microsoft?
Well, let me. We did have a disagreement on that case, but it wasn't so much the size of the case. I mean, I was not afraid of doing a big case. I mean, I had learned a lot doing the insurance antitrust litigation, that you can manage that kind of case even if you have people in a dozen different AG offices across the country. It can get done. It can be managed. My concern was that it appeared that DOJ had that case well in hand in 1995 when they got their consent judgment approved, and then subsequently they had appeared to be investigating a broader case, although it turned out that they were primarily focused on the consent judgment that they had obtained in 1995. And my analysis of that consent judgment was that it was likely not to be very effective. It couldn't really deal with the changing technology going forward. And so I understood there was a huge public policy problem that needed to be needed to be dealt with. But I thought DOJ was in a better place to do it than the states at that point. Belated, and I know that you and others were doing a terrific job unearthing all kinds of evidence, including the Microsoft's proposal to Netscape in June of 1995, just a month or two after the consent judgment had been entered into. Microsoft proposes to Netscape to essentially allocate markets. That kind of stuff got unearthed, and I think you deserve much, if not most, of the credit for doing that. And so when I started learning belatedly about some of this stuff, I realized, well, I got more interested, but I still thought DOJ should be involved. And it wasn't until '97 when you and others came to me as task force chair and said, look, we don't think they're going to bring another broader action, and we need to get the states coordinated, because at that point Texas and New York, and I think it was Massachusetts and a couple other states were all issuing CIDs, and sometimes multiple CIDs were going to the same third-party witnesses, and so we needed to get coordinated and get organized. And that's when I became more involved, and through the early 1998, in the spring, I became very involved and became very much convinced that it was a toss-up whether DOJ was going to go forward with a broader case or not.
Which was an interesting dynamic. Did you have any interactions with the Department of Justice about what the state's intentions were in Microsoft?
Well, initially my interactions were at the staff level, dealing with confidentiality agreements, discovery issues with Phil Malone and others in the investigative staff. Eventually, I started dealing with Joel Klein and basically told him, I think it was April of 1998, that at least a dozen states had already approved filing a broader lawsuit against Microsoft, and there will likely be more, and that we would like to do this with DOJ, but we can't determine whether DOJ is prepared to go forward with a broader case or not. And eventually Joel came back and said, well, yes, we are going to file a broader case, and it makes sense for us to do it together. And as you know, that case was filed in late May of '98, and I think we had 19 states on, and we wish we would have had 20 states on, including Texas. But your boss decided not to jump in at the 11th hour, right?
That's right, and I've had Microsoft envy ever since. but let me ask
Mark.
you,
we all felt sorry
yes,
for you, Mark.
Before the case was filed, were there any efforts to try to resolve the case to prevent justice in the states from filing?
This is one of the hairiest moments in the whole case, in my view. Just before we were about to file the case, we gave notice to Microsoft that it was going to be filed, and I think it was Bill Gates called Joel Klein and said, we ought to talk about how we can resolve this. And so we trooped off to Washington, we being you and me and Steve Houck, who was our lead counsel from New York, and Tom Miller, the Attorney General of Iowa, who was our AG liaison. Together with the Department of Justice folks, Jeff Blattner and others, we sat down with Microsoft's attorneys. At first we thought Gates would be there himself, but he wasn't. But Bill Newcomb and Dave Heiner and Tom Burt were, and we had a 2.5-day meeting where essentially it consisted of Microsoft asking us, what do you want? What kind of relief do you want? And we hadn't thought about it. Neither had DOJ. I mean, we had been so busy getting ready to file the case, we never expected this. And so it was very uncomfortable, and we kept coming up with these fairly minor things that we would put on the table about, change the desktop to this and allow that and allow this, and nothing too major. Well, you remember, it wasn't too, wasn't very dramatic. And so what, at the end of 2.5 days, when Microsoft came back in the room and said, well, we're not going to take any of that, and we're not going to talk further about this, we were actually relieved, because we didn't think we had done we didn't have sufficient relief on the table, but we didn't know how to. The first thing I did after the case was filed and we got our next multi-state conference call, is we set up a remedies committee among the state AAGs working on the case, and we had people, while the case we were preparing the case for litigation, we had people doing interviews of Microsoft's competitors talking about remedy. What kind of remedy would work here? Would compulsory licensing of Windows work? Well, probably not, because you need to not only the license, but 200 or 300, 400 of the Microsoft's best engineers to figure out exactly how it works. And it was that kind of response. And so we went through a long checklist of remedies and eventually settled on divestiture of the Windows and Office systems divisions of Microsoft as the best remedy, both from the perspective of the consumer and perhaps from Microsoft's perspective. But I wouldn't presume to speak for them. But I really did think that, like the AT&T divestiture remedy, I thought there was a chance that this would be perceived even within the company as something that might work.
So when the case went to trial, Steve Houck was the lead for the states?
That's correct.
But at a certain point in time, you took over and Steve transitioned out, right?
Right. Steve, the case went to trial in the fall of '98, and through early '99 it was still being tried to Judge Jackson. And Steve did an excellent job as lead counsel. He's just a phenomenal litigator. He came out of Donovan Leisure and really had a lot of experience and savvy and confidence in the courtroom. But he was actually, the case was brought while Attorney General Dennis Vacco was Attorney General of New York, and Steve was Dennis's appointee. And even though he's non-political in a pure sense, when Elliot Spitzer came in, he wanted to replace Steve, and the rest of the states, including myself, fought real hard to keep Steve on board in this case because it was such an important case and he was such a presence in the courtroom. And I think Steve stuck around for another year or so, and then eventually he left the New York AG's office, and that's when I assumed the lead counsel role for the states, and in particular went through the mediation with Judge Posner that was unsuccessful, and then later the remedy phase where we argued for the breakup of the company.
We're getting nearer the end here, but I don't want to pass up the opportunity, given my Microsoft envy, of hearing just a little bit about whatever you can say about the Judge Posner mediation.
Oh my gosh!
The states have really been blamed, I guess, is fair to say, for that mediation not going forward, perhaps even by Judge Posner. What can you say about that?
It was an interesting mediation. I've been involved in a significant number of mediations, and I've never had one where the mediator essentially takes control of all the drafting and the parties never actually talk face to face or even on the telephone or any other way. It was a mediation, and I'm not saying that that's not a valid mediation model in some cases. I thought that in this case there was a need to be able to understand more directly what Microsoft was saying would work and wouldn't work. But Judge Posner chose to do it that way, and drafts were being generated on a weekly basis, practically, of a very complicated conduct remedy, and I was very skeptical that we had something that would work over the long haul, or that even would be pro-competitive in some sense, in the sense that it would put the shackles on Microsoft software development at some level. And eventually, at the end, I think there was in Judge Posner's mind, I think he thought that they were close to a settlement between DOJ and Microsoft, although I don't think either one of them had ever indicated they were ready to sign a draft. And the states at some point were a little bit out of the loop and brought in somewhat belatedly, and some of the AGs in particular became very upset about that, and that they were being asked to sign off on this very complicated draft with just a few days remaining before the somewhat arbitrary deadline was imposed. And I can see where some folks might argue that the states were, responsible. I just don't believe that. I don't think Microsoft was prepared to sign that decree either. But how would I know? We never actually talked to them directly. And so, so when that fell apart, Judge Jackson issued his conclusions of law. We had the remedy hearing. I was one of two folks who got up and argued for divestiture, which I still think of as a high point.
You and David Boies, right?
Yeah, well, of course, he had me go up first, so I got all the questions, and he got to prepare his response while I was up there. Yeah, it was very surprising when I went up there because I was all prepared to defend the idea of divestiture, and the first question Judge Jackson asked was, well, why divided the company in two parts? What about this other proposal to divide it in three parts? And frankly, that was not a question I expected. I'm not sure anybody else on our side expected it either. We thought we were going to have an uphill battle with divestiture, but he seemed to be inclined to accept it right from the get-go.
And you were also involved in the appellate argument in front of the D.C. Circuit, right?
And preparing for it, we had a debate about how we would prepare for that. One of the issues there was because Judge Jackson had had some private meetings with reporters in his chambers, there was an ethical / judicial conduct issue involved in the appeal, and we were afraid the whole thing was going to be thrown out. So we just, by then Harry First was running the New York AG office, and we had a number of state candidates to do part of the appeal with the DOJ doing the other part. And we decided that we needed somebody who could actually had some serious credibility with that court, and we brought in John Roberts, who was then a partner at Hogan and Hartson, and now, of course, Chief Justice of the Supreme Court. And he did that part of the argument for the states, and very successfully, I might add.
So, Kevin, we're here doing your oral history for the American Bar Association section of antitrust law. You've been very much involved in the ABA antitrust section. Why is that?
I've been a member of the ABA's antitrust section since getting out of law school because I actually worked on a publication for the ABA antitrust section when I was still essentially in grad school back in Madison. Right, I wrote a pamphlet or a monograph on conglomerate mergers. That's something we never talk about anymore. And so I understood the value of the ABA publications. I mean, this is where I do the commercial for the ABA section of antitrust law. No, but I always felt it was a great organization from a publication standpoint. And when I became NAAG chair, antitrust task force chair, I decided, I became aware that I became the liaison, the spokesperson for the group within the ABA section of antitrust law.
So do you think the states still have an important role in antitrust enforcement?
Absolutely. Our system of concurrent enforcement is a real strength of our system, not a weakness. It's not. I understand there are some critics, people who don't agree with that point of view, but we generate so much case law. We're all in the same court systems trying to generate case law and bound by that case law. I think it's really an important part of our system and a strength of our system. And I've written articles about this, so people can go look those up in the Antitrust Law Journal.
Some people have a different opinion, and they say that the presence of multiple enforcers can cause divergence. What's your view on that?
I think it can in the sense of it causing divergence in terms of what cases are brought, but at the end of the day, the cases have to meet the standards of the essentially the federal antitrust case law, and so aberrant cases generally fall by the wayside. And I don't see the states bringing too many bad cases. They tend to win most of the cases they bring, and so I take issue with that. I mean, the fact of the matter is, well over 70, maybe even over 80% of antitrust litigation is business v. business, and so I think it's an issue that goes way beyond state AGs.
Well, Kevin, thank you very much.
Well, great. Glad to have this opportunity to talk to you, Mark.